looks like we have Commissioner Kirby's here. Great. And we will have an absence from Commissioner Montemayor. He is at a wedding. So we will get started. At this time, I'd like to call the meeting to order. Today is Thursday, August 26th. And this is a meeting of the Rent Stabilization Commission, for the City of West Hollywood. Commissioner Topshian, would you like to lead us in the Pledge of Allegiance, please?
Thank you, Chair. I pledge allegiance to the flag of the United States of America and to the republic
for which it
stands,
stands,
one nation, under God, indivisible, with liberty and justice for all.
Wonderful. Thank you, Commissioner. Mr. Secretary, may we have a roll call, please?
Commissioner Ayers.
Here.
Commissioner Kirby's.
Here.
Commissioner Maggio.
Present.
Commissioner Montemayor is absent tonight. Commissioner Topshian.
Here.
Vice Chair Copeland.
Here.
Chair Marks.
Present. Thank you very much. We have a quorum. All right. Has everyone here tonight had a chance to review tonight's agenda? I see head nods. Wonderful. Would anyone like to make a motion?
I'll make a motion to approve the agenda for August 26, 2021.
A second.
All right, we have a motion and we have a second. Mr. Secretary, a roll call, please.
So sorry. Commissioner Ayers.
Aye.
Commissioner Kirby's.
Aye.
Commissioner Maggio.
Aye.
Commissioner Topshian.
Aye.
Vice Chair Copeland.
Aye.
Chair Marks.
Aye. Thank you very much. The motion has passed. And next item on the agenda, approval of the minutes from our last meeting. Has anyone had a chance to review the minutes?
I'll make a motion to approve the minutes of August 12, 2021.
Thank you.
I'll second that.
All right, we have a motion. We have a second. Mr. Secretary, a roll call, please.
Commissioner Ayers.
Aye.
Commissioner Kirby's. Commissioner
Aye.
Commissioner Maggio.
Aye.
Commissioner Topshian.
Aye.
Vice Chair Copeland.
Aye.
Chair Marks.
Aye, the motion passes. Thank you very much, everyone. Do we have any speakers from the public for public comment?
No speakers at this
Okay,
time.
wonderful. Thank you. I appreciate that. All right, next on the agenda tonight is the manager's report. Mr. Hollab, a report, please. Hello.
Good evening. Thank you, Chair Moritz. Good evening, commissioners. I'm Jonathan Hollab. I'm the Rent Stabilization Housing Manager, and this is the look ahead calendar. Tonight we have one appeal. We'll also be bringing forward the rent stabilization regulation update related to the interest on security deposit that we discussed at the June 10th meeting. So that will be a regulation for your approval to send off to City Council. Also, staff will be announcing the interest rate of security deposits under the existing formula. We have one appeal on September 9th, which is our next meeting, two on September 23rd, two on October 14th. And at that time, we anticipate that the Ad Hoc Committee on Valuation Guidelines will return with their report on that subject. There are no other items, but I definitely anticipate other things being added. I'll just point out that you'll notice there's no meetings in November. That's because both of the regularly scheduled commission meetings are on holidays that month. And I know I sound like a broken record, but I encourage anyone who's watching who has accumulated COVID related rent arrears to visit housingiskey.com. And that applies to both tenants who've incurred arrears during the local emergency and also landlords who have tenants who've incurred arrears. 100% of that debt can be cleared through that program. So even if you aren't sure if you're qualified, check it out, please. There is funding available, and there's a lot of good information on that website. And if you need help with anything, feel free to contact the division rsh@weho.org. Thank you.
Wonderful. Thank you for that. Commissioners, any questions? All right, seeing no questions, we will move on to commission comments, part of our agenda. Commissioners, any comments to make? Yes, Commissioner Kerpes.
Yeah, I just had two things. One, I wanted to thank Jonathan for bringing the item, the rent, or I'm sorry, the interest rate item to us tonight. That was very quick, and I look forward to talking more about it later tonight. But I really appreciate it coming back to us so quickly. And also, I just wanted to follow the broken record and about the housingiskey.com. And there's been a change recently. It won't affect any of our residents here in West Hollywood or any people that are probably viewing this recording or this event tonight. But all residents of the city of Los Angeles who have not had an opportunity to apply for the city's rent relief program, beginning 7 a.m. on September 1st, can now apply to the housingiskey.com. So if you have friends, neighbors, relatives that are in the city of Los Angeles, please let them know that. That's September 1st at 7 a.m. They can go on to housingiskey.com and apply for that money as well. So thank you.
Thank you for that. Commissioner Kerpes' question. I know that past comments you've said that to apply directly to the city of LA because they had a separate program, are they discontinuing their program and moving everything to the state, or is it a dual program?
No, their program, they're actually handing over the administration of it to the state, which also will allow the state to more easily add more funds to the available money for LA tenants. So it's a win-win for everybody, really.
Great, that sounds awesome. Yes, other comments?
It's actually, if I may, it's a question for Commissioner Kerpes. You said September 1st, 7 a.m. until when?
Technically until the money runs out.
Okay.
So they don't have to sign up on the 1st, but starting at 7 a.m. on the 1st, they can begin applying, and everyone else can still apply. But the money is only there until, we don't think it's going to run out, but you never know. So apply if you even think that you might qualify.
Okay, thank you.
Wonderful, good question. Any other comments from other commissioners? No, seeing none, I will give one. So we just got news this evening that the US Supreme Court has done away with the eviction ban from the CDC and the federal government. So there's going to be some scared people. We don't know how it will trickle down to us, but we should be aware of it. It's a housing matter. I would remind people that the state of California has their own eviction moratorium in place. So people should be knowledgeable about what's going on, but hopefully the state will still be there to protect people. But people watching should speak to their legal representatives if they have them. There's nonprofit legal help, but it is a change. So I want people to be aware of that. All right. If you do have any other commissioner comments, we'll do those at the end. Moving on, we are now at the appeal portion of the evening. We have one appeal tonight. It is D-4503 CD2. Mr. Secretary, do we have representatives from both parties here?
We do, and they're being admitted now.
Wonderful. All right.
Hello.
Yes, Mr. Sepernia, I apologize if I butcher your name. And
Yes,
it looks like, perfect. Nice to meet you. And we have Mr. Frost here as well. Is that correct?
That is correct. I'm counsel for Rolly Dennis. He wanted to be here himself, but he's stuck in England with a family emergency.
Okay, thank you for that. So we have a legal representative or a representative for the tenant, and then we have the property owner here as well. I'll explain briefly what we have. First, we're going to hear a staff report from our legal counsel, and then the appellant in this case will speak first, the person that filed this appeal. That is Mr. Sepernia. You will have a total of 5 minutes to discuss your appeal. You can divide the 5 minutes into 2 segments, the opening and your rebuttal. You will be able to tell us how you want to divide that time after the staff report. So think that through. You can do 1 minute to start, 4 minutes to rebut, or any other version of that, adding up to 5 minutes. The respondent, which is the tenant, will speak second, and you'll have a total of 1 5-minute segment to state the case, which will be followed by the appellant's rebuttal. And when you speak, you'll unmute yourself, so you can go ahead and mute yourself now. You'll state your name, your city of residence, and then the appellant will tell us how he would like to divide your time, and then you'll proceed with your comments. So again, first we'll start with a staff report from our legal counsel, and then once that's finished, I will give further instructions and start the comments from both sides. Thank you. Legal counsel.
Good evening, Chair, Vice Chair, Commissioners. My name is John Natalizio. I'm the legal counsel to the Rent Stabilization Commission for the city. This appeal was filed by the landlord, Stefan Sepernia, in response to this case's file most recent compliance determination. The tenant, Thomas Dennis, who resides at 1009 Havenhurst Drive, originally filed an application seeking a rent reduction for a number of issues. However, relevant to this appeal, the application sought the replacement of a living room heater. The hearing examiner's original decision, which I'll just refer to as D4503 decision, in part granted a rent reduction of $91 related to that living room heater. According to the hearing examiner, the city issued a notice to landlord that the unit lacked safe and adequate heating in accordance with the RSO, specifically West Hollywood Municipal Code Section 17.56.010A3. Landlord removed the old furnace from the wall and patched the adjacent wall and floor. However, landlord did not replace it. The hearing examiner determined that by not replacing that living room heater, the landlord had abdicated his duty under the Municipal Code Section 19.000.30.f.1 to provide safe and adequate heating facilities in a dwelling unit. Landlord filed a request for a compliance determination that he had complied with the orders of the original D4503 decision. Landlord installed a new 5,200 BTU heater and provided to the city a receipt for purchase of the electric wall heater from Amazon, which identified the heater as a Phoenix smart heater. The city issued a notice for work performed by the landlord, which informed tenant of landlord's request for a compliance determination. Tenant objected to the request, claiming that the heating issue was unresolved. Tenant claimed that the landlord replaced the heating with an inadequate space heater attached to the wall and claimed that it had a maximum capacity of 5,000 BTUs. Tenant argued that the heater is inadequate to heat the living room and kitchen, and it does not function to the ability of the previous gas furnace. An inspection was performed by a code compliance officer to determine whether the heater adequately warmed the living room and to determine the size of the living room. A determination was issued which denied that request for a compliance determination. The hearing examiner determined that a new heater was not as powerful as the old heater, and unlike the old heater, it did not vent to the kitchen. Ultimately, the hearing examiner concluded that since the old heater warmed the kitchen as well as the living room, the inference must be drawn that the heating has not been restored to the extent it was before. Landlord appeals and claims that the determination is clearly in error, is not reasonably supported by the findings made or evidence in the record, constitutes an abuse of discretion, and is contrary to specific provisions of law. Staff has reviewed the appeal record and recommends remanding the case back to the hearing examiner for further evaluation and analysis. Based upon the determination, staff is unable to conclude and recommend whether or not the determination is supported by substantial evidence. Staff believes the hearing examiner's determination failed to analyze specific facts and evidence necessary to determine whether landlord has complied with the D4503 decision. In summary, staff found that the hearing examiner did not consider landlord's compliance evidence, failed to adequately analyze why heating the kitchen must be considered for compliance with the original D4503 decision, failed to adequately analyze why the temperature increase cited by the inspector is insufficient, failed to adequately analyze whether a 5,200 BTU heating appliance is sufficient to comply with the original D4503 decision, and failed to adequately cite to his independent sources of research. For the sake of brevity, staff specific recommendations for remand language are set forth in the staff report and resolution. Therefore, based upon the above, staff recommends adopting resolution RSC 21-598. You as the commission have the power to affirm, reverse, modify, or remand the appealed decision of the hearing examiner. The commission reviews the hearing examiner's decision under the substantial evidence standard, which requires the commission to make sure there's substantial evidence that reasonably supports the hearing examiner's decision, is credible and of solid value. If that evidence is found, then the decision must be upheld, even if there's also evidence that could support a different outcome. The commission does not substitute its judgment for that of the hearing examiner or reweigh the evidence. As it relates to questions of law, the commission applied an independent or de novo standard of review to the hearing examiner's conclusions of law. Thank you.
Wonderful. Thank you very much for that summary. Any questions from commissioners? Yes, Commissioner Topsian.
Thank you, Chair. A quick question to the legal counsel. The description in the determination of the examiner under testimony and exhibits, it mentions the whole house. Wouldn't that be including the kitchen area and any other area when it's discussing about the heating? So wouldn't it be the presumption?
I guess if I understand your question correctly, are you asking whether or not the I'm sorry, could you just restate your question? I'm not understanding.
I guess I know that we are remanding it to the examiner. One of the reasons is because the kitchen was not mentioned in the hearing specifically, the kitchen. But if we read the testimony and exhibits part that references the residence, and it also lists what we include in the residence, the living room, dining area, kitchen, and everything. And then under heating, specifically the heating part, that was discussed that the furnace does not heat the whole house. So by saying the whole house, in my opinion, that would include any area. So I would presume that this also would apply to the kitchen, and the presumption would be that it also talks about the kitchen as well. So I'm thinking, what would be your thought?
So the application itself, the original application involved heating of the unit, but it was specifically relating to a heater that was in the tenant's bedroom that has been replaced, and that has not been appealed. And then the heater in the living room. I guess maybe when we get to the deliberation part, if you want to, I guess, point to me directly where you're looking, I can look at specifically what you're looking at, but at least my understanding of this is that the application originally was relating to the living room and to the heater that was in the tenant's bedroom, which is in the back of the unit. And ultimately, if the commission finds that the language is met, I mean, the commission can deliberate and say that they believe there's substantial evidence and deliberate on that. You don't have to remand it. That's just staff's recommendation. So I guess at this point, my recommendation would be we can get to the deliberation, and then you can point to me where you're looking, and I'll try my best to answer more clearly.
Yeah, I just wanted to kind of grab your thought on it, but thank you. We'll probably get back to it. Thank you, Chair.
No problem. Yes, Commissioner Kirby's.
I have two questions, kind of a follow-up to that, understanding that we can talk more about it later. But let's, if we were to assume for a moment that the commission viewed the heater as there was a heater in the back part of the house and a heater in the front part of the house, and forget about the details of where it exactly heats. How does that change your analysis of the hearing examiner analyzing the evidence? Like you give examples of how the hearing examiner, maybe didn't support his analysis of whether it heated the kitchen or not. But if we were to remove that, what would be remaining of your analysis that would still recommend, or would you still recommend remanding it to the hearing examiner?
So, I mean, that's a good, it's a good question. I mean, the fundamental issue we're looking at really is based upon the original hearing examiner's decision. And what that cites to is that the hearing examiner determined that the unit wasn't being heated in compliance with the city's municipal code requirement. And that was that section 19, sorry, give me 1 second. That was the section 19.030.30F1. And that requires adequate and safe heating to a dwelling unit. So that's the fundamental language that we need to look at. The issue that I was referencing in the staff report, and the reason why I recommend the remand, is that the focus on the kitchen specifically, it just, in my opinion, wasn't explained as to why specifically the kitchen was being pointed out, and specifically because the hearing examiner stated, sorry, I have the quote here. His quote was, "Since the old heater warmed the kitchen as well as the living room, the inference must be drawn that the heating has not been restored to the extent it was before." And so they're just, to me, singling out this kitchen when the original application and the original decision had no specific focus on the kitchen. Just didn't make sense to me as why that would then be the basis for whether or not the landlord complied with the original, D4503 decision.
So if the commission were to disregard any of the mention of the kitchen specifically, or the basis for which the hearing examiner came to his conclusion about whether the kitchen was heated or not, or whether it should or shouldn't be heated, is what I'm hearing you say is that the only decision left, well, no, I'll put words in your mouth. The only, I guess what I'm trying to get is which other portions of your recommendation would support us remanding it. If we felt as a commission, we could deal with that question of whether the heat was sufficient under the code.
I see what you're saying. So you're saying if the commission ultimately found that the heat was insufficient, would my recommendation still be to remand? Or would there still be provisions of my recommendation that would stand for a remand? Is that the?
Yeah, that's probably what I'm.
So I'm just looking at the summary in the staff report. So part of the issue was that the hearing examiner didn't consider the landlord's evidence that he submitted in support of his compliance determination. The hearing examiner's decision states that he didn't submit any evidence, and I mean, there's no dispute that the landlord did not install the heater. That's agreed to. He did install the heater. It's just the argument of whether or not it was sufficient. And one of the things the hearing examiner noted in his decision is that he had conducted independent research that confirmed that the landlord's belief that heater would be sufficient was incorrect. But he doesn't state what he looked at, what he researched, how that supports his decision. And one of the examples that I gave was that had he looked at the evidence submitted by the landlord, he would have seen like the make and model, and then it could have at least on some level looked at whether or not the manufacturer, for example, is saying that this is sufficient to heat, a 300 square foot room. And maybe that would change his analysis about whether or not the landlord complied. If he's looking at, a living room that's like, I think it was like a little over 200.
Well, and the
square
landlord
feet.
could also say, no, I disagree. That's
Sure.
not the evidence I have, right? I mean,
Right.
you could say, no, that right now we don't, the landlord did not have that opportunity on that point to be able to refute that.
Right. So that's one basis. The second basis would be when the inspector went out to the property, she made two findings regarding the heat. One was that in 20 minutes, she saw the heat go from, I think it was, give me one second.
69 or 61.
Yeah, it was like 54 to 59. There's some heat increase. And then the second comment she made said something to the effect of, when I walked into the unit after, I think it was like 20 minutes, she wasn't able to pick up any perceptible heat, something to that effect. And so the hearing examiner only looked at that second observation and not the first, involving the heat increase. And so part of my recommendation is that if the inspector saw a X degree heat increase in just 20 minutes, that should be evaluated in terms of whether or not that heat increase is sufficient to comply with that D4503 decision. And let me see here. Oh, and then lastly, I just said that he needed to determine whether or not, because he didn't actually know the make or model of the heater, so he needed to determine whether or not the heater and ultimately the 5,200 BTUs was sufficient to comply with the 4503 decision. So I guess that's just a long-winded answer.
No, I
I
appreciate
still think there's other things that could be remanded, but ultimately, again, the commission could overrule all that.
I appreciate that. That helps me understand it better. I did one last question about the actual health and safety code, or the. Can you explain? We have lots of cases that come in front of us that, let's say there was no reference this evening to the code about what's required for the health and safety code. We would still be having this conversation about whether the service was replaced or not, or reduced. So does that change how we think about this case from other cases because the code is cited? Because I kind of felt as I was reading the case that he did mention it, but it didn't sound like it was solely because they weren't in compliance with the city's code that he ordered that the heater be replaced. So I don't really know my question. I guess I've already asked my question. What is that? How is that significant versus?
Well, this is significant in the fact that this specific section, so the RSO section of how this ties in says that the units need to meet all essentially health and safety standards, city, local, state. And so that one of the city's code requirements in that section 19.030.30F1 requires that that landlords have to provide a safe and adequate heating facilities in a dwelling unit. So I think this is a little different in that the significance that this is like an actual code violation, whereas I think traditionally if we're seeing something with a rent decrease, like last week, I believe it was like, painting, or it was, not having carpeting. So I guess in this, they're code violations in the sense that we have an RSO and maintenance standards, but this was outside of the RSO and that there was an actual section of the municipal code being violated.
And do we have any authority or say over that? I mean, our decision tonight is based upon whether the service was reduced and if the dollar amount associated with it is appropriate. right? Not
Right, yeah.
waive him or to approve his meeting of the code.
Right, yeah, no, that would be outside of the scope of the specifically appeal and also the commission. Tonight, we're just focusing on whether or not there is substantial evidence to support the hearing examiner's decision, including, and in this situation, it's not even the $91 because this is just a compliance determination. So what the commission is looking at is, did the hearing examiner correctly determine that the landlord did not meet the original order in that D4503 decision? So if the commission was going to have any sort of this ability to change the $91, it would have had to have been, on like an original appeal of that decision, which I think was like back in 2020. This has been going on for a while.
Thank you.
Further questions? Yes, Vice Chair Copeland.
Hi. When you're asking for a remand for the hearing examiner to provide more explanation about the comparison, are we asking for specificity between the old type of heating, which appears to have been a forced air gas furnace with vents, and the electric wall unit, and why he felt they were not comparable? That's what you're asking in that part of the remand, is for specificity and details of what his research entailed to compare them?
Well, that's certainly one of the things, and I think that's a very good point to bring up, is that at least from my reading of the original decision, there isn't anything discussed about what that original furnace, what its actual output was.
I know there was a mention on 38 and 39 about a photo was introduced of the old, which vented in both the living room and kitchen. So I took that to understand that this was a forced air gas heating
Correct.
system with vents in different places. So are we looking for more specificity about the comparison and why it's not comparable to the original system? Is that part of the remand? Is that what we're looking for? Or?
I mean, that certainly can be part of the remand. Again, when we're looking at the original decision and its language, we're just, we're looking at whether or not the landlord complied with that. I guess I don't know if the landlord needs to have replaced the original gas furnace, setup with a new gas furnace setup, or if this wall unit is sufficient, or two walls, units are sufficient. I don't think that that's, at least for me to say, but one of the things certainly can be exactly what you're saying, which is more specificity about why that prior furnace was more powerful or more efficient or heated more than what is currently being utilized. And so that is certainly something the hearing examiner could consider.
Okay, thank you. That's it for me right now. Thank you.
All right. Any other questions from commissioners before we go into comments from the parties? Nope. Great. Okay. Thank you, legal counsel. All right. As I said earlier, the appellant will speak first. That is Mr. Sepernia. You will have 5 minutes to speak total. You can split your time however you want between your opening and your rebuttal. The respondent, who is tenant's legal counsel, will speak in the middle for 1 5-minute uninterrupted segment. All right, so Mr. Sepernia, you can unmute. It looks like you're unmuted here. Please state your name and your city of residence, and then explain how you would like to divide your time.
Stefan Sepernia, West Hollywood, 2 minutes and 3 minutes at the end.
All right, Mr. Secretary, if you could take that down, and Mr. Sepernia, you may go ahead with your 2-minute opening.
Yes, hi. My opinion doesn't matter. I'm going to state the fact. This case is only about the living room heating, not the kitchen. Kitchen never had heating. As far as the whole house, this was a old floor furnace for 96 years old, which for the last 25 years, it never hardly worked. I brought all the technicians, they couldn't make it work. I already in 2018, I put a wall heater that I came to the city, talked to Eugene Alper with his directions. I put a large unit in the back, which has 18,000 BTU, which covers 1,600 square feet. This whole unit is 1,100 square feet. So the case is about the living room heating. Living room heating, the living room is only 10 by 12, which means 120 square feet. The heating that I put in there, it produces 5,200 BTU, which covers 500 square feet. This unit is efficient, adequate, and strong. I made a lot of, I searched and I looked for something that is gonna work perfectly. I brought a technician, a heating technician, and he had an autometer sensor that he measured it. The temperature goes 2 degrees every 5 minutes, which makes it 24 degrees temperature in 1 hour. Even if we go with Inspector Lopez's finding, still there is 12 degree of temperature in 1 hour, which is efficient, which is adequate. There is the heating technician who is available to give this and to give this as a witness if you're allowing them. This also has to be said that the commissioner said—
Mr. Bernier, your
Yes.
2 minutes is up. Do you want to keep going or stop?
No, stop.
All right, thank you. All right, so now we will hear from the tenant's legal counsel. Again, you have 5 minutes to speak. This is one interrupted segment. This will be your only time to speak. And I will note, please keep on topic and only discuss evidence that was raised at the hearing or evidence submitted to the hearing examiner, nothing new. And again, please state your name and your city of residence, and then your 5 minutes will start after that. Thank you.
I'm Christopher Frost. I'm the chair of litigation at Eisner LLP with my office in Beverly Hills. My client, Rolly Dennis, is a resident of the city of West Hollywood.
All right.
This panel does not have to divorce itself from reality or from common sense. I was with Mr. Dennis when we appeared in the first hearing, where we talked about the evidence. There were photos of the heater, and we talked about why it was insufficient. The reality is that house had a forced air gas heater that would come up from the floor that would heat the entire unit. That was found to be insufficient for the replacement because there was not sufficient heat for the living room, dining room area, and it also didn't heat the kitchen. When you look back at that report, and when you look back at what the subsequent findings were, they were there. The inspector was there, looked at this and said, I waited for 20 minutes and that heater did not put off enough heat to heat the room. For context, Mr. Cipernia's analysis that said that because it heated a few degrees over 20 minutes means that it will continue to heat at that rate for the entire time that you leave the heater on is simply divorced from reality. 20 minutes later, the finding was made that they had to get within 2 feet of that heater to even feel the heat. Mr. Cipernia's testimony regarding what the square footage of the space was, the living room, is directly refuted by the findings. The measurements that showed the living room, dining room combination was 300 plus square feet. And the fact that they went and they did their independent research to see that this unit was not big enough to support that size of an area is sufficient in and of itself. And the idea that we would suggest we have to remand this, to have them make further findings, to come to a conclusion that were obvious when they were in the unit itself, is simply preposterous. The fact is that Mr. Dennis has been dealing with this landlord for years on a number of issues that will not go away, and the heater is just one. They're dramatically concerned because they were in England having a baby that they are now going to bring into a space that, if this is remanded, will keep it from being sufficiently heated for many more months. There is no reason for that to happen when you have a clean record and a clear record that there was a violation of the obligation to provide sufficient heating for this unit, let alone that was sufficient to meet what the prior heating had allowed. And to suggest that we're going to have to go through more process to get to that very obvious conclusion because he hung a small wall heater on the wall is simply preposterous. The fact is that house is not warm. The inspector found that. Mr. Sapernia is trying desperately to find a way not to put another heater in there. The reality is, if you would just buy a big enough heater, the whole problem would go away. But you have a sufficient record to understand there was not a good enough unit in there. There still is not, and the recalcitrance and the refusal to provide a heater that will allow this family to live comfortably has got to stop, and it should stop today.
All right, thank you, Mr. Frost. All right, any questions for Mr. Frost on behalf of Mr. Dennis from commissioners before we go back to rebuttal? All right, seeing none. Thank you, Mr. Frost. Mr. Secretary, how much time does Mr. Sapernia have left of his 5 minutes?
2 minutes and 45 seconds.
2 minutes and 45 seconds. All right, Mr. Sapernia, you have 2 minutes and 45 seconds. Again, no new evidence, just old evidence that was raised at the hearing or submitted to the hearing examiner, and please stay on topic, and your time starts now. Thank you.
If we're talking about the whole house, then you're ignoring the wall heater that I put in the back, which has 18,000 BTU, which covers 1,600 square feet unit. This unit is only 1,100 square feet. So again, this particular case is about the living room, and the living room, the new smart heater that I put in is completely efficient and adequate. When I was going to install this living room heater, Mr. Dennis himself insisted, not just asked, for me to put a smaller. I was going to put a bigger unit. He said it's not needed. He needs the space for his computer. The room is small enough. A smaller heater is enough. I have a witness. The general contractor was there. I have his name. We went with Mr. Dennis's request to put a smaller unit. We found a smaller unit that has 5,200 BTU, covers 500 square feet. This is a smart heater. It evens out the heat. It doesn't blow it in your face. I spend a lot of money. Mr. Dennis asked me to put a new circuit, which I did. I went back to the house 10 days later to investigate. He did not complain. 2.5 months later, the city wrote to me that he has complained. He had ample time to complain to me within the first 2 weeks, and so I could take it and return it and get another one. It was his specific request to put a smaller one, and I put a smaller one that covers 500 square feet of the living room and adjacent. Kitchen never ever had heating, and this heater is perfectly fine. And I had this technician. The hearing examiner is not an expert. Inspector Lopez is not an expert of heating technician. The technician that I took there had an odometer sensor, and he measured it. 2 degrees every 5 minutes is 24 degrees per hour. That's plenty of heat for a very small living room. And I have complied with everything first before I install anything for Mr. Dennis. I first come to the city to quote compliance before I do anything. Yes, Mr. Dennis has given me a lot of time.
That's your time.
All right, Mr. Sapernia, time is up. Thank you for that. Commissioners, questions for Mr. Sapernia? Yes, Commissioner Kerpes, and then followed by Mr. Maggio. Commissioner Maggio.
two questions for you, sir. First one, I didn't read in the record, and so please let me know if the evidence that you just were speaking of about you having your inspector come in to 2% or 2 degrees, was that evidence presented to the hearing examiner?
He's on the line right now for
No,
detail.
I'm sorry. Was it presented to the hearing examiner in the hearing for this prior to this?
I mentioned it to Roger. Yes, I had told Roger and he instructed me to tell the technician to go online right now so you can discuss it with him.
No, I'm not talking about Roger. I'm talking about the hearing examiner. When you went to when you had the hearing that you have appealed, the hearing examiner, did you present this evidence to him?
No, I asked,
okay.
well,
Thank
that
you.
wasn't hearing examiner. I requested that I be there when Officer Lopez.
Thank you. Yeah, thank you. The other question I have for you is, you had offered Mr. Dennis to install the heater in the dining room, correct? The dining room window, I believe it was.
Yes, I told him I could do that.
So under that argument, are you saying that if it were in the dining room, would you be in compliance with the order of heating the living room? If we were to believe that the hearing examiner is only focused on the heating of the living room, then would you be in compliance if you had submitted or put the heater in the dining room window?
I don't understand your question because this is about the living room heating. He said the floor furnace was in the living room and he wanted to replace the heating in the living room.
And
so
my question is, if that is the case, then why would your offer to put a heater in the dining room window comply with the order?
Well, both heaters, the current one or the one in the window in the dining room, would be sufficient enough for both rooms. Both rooms are very small.
Thank you.
All right, Commissioner Maggio, question.
Yes, my question to the owner is that in regard to the old floor heater, you did bring people in to inspect and examine that old heater? And if so, what were their conclusions?
Every other year, I had to bring a technician to fix it because it was not working and it was not generating heat. It was dying out all the time. The thermostat would not correlate with the heat. It was producing a lot of gas. So it became very dangerous. I came to the city of West Hollywood to the compliance, and they told me, and it was 96 years old, and nobody could fix it. No technician knew how to. So the city told me to cover the vents and told me that I can put that wall heater in the back, which produces 18,000 BTU, and it's covering 1,600 square feet. And this Eugene Alper told me that should be sufficient for the whole unit. And in the code in the city of West Hollywood, there is no question about the number of units that the landlord should put in. So I was under the impression, discussing it with Eugene Alper, that's what I needed to do, just to put that one in the back. However, when Mr. Dennis wanted something in front, I consulted again with the city, and the city said, okay, if he's agreeing, if he wants something in front, then you need to put something in the living room where the floor furnace was covered. So I put this unit, but Mr. Dennis insisted I put a smaller unit, not a larger unit, because it was a small room and he needed the space. So I found this unit, which is sufficient. And
Let's wrap the answer up. I think that answered, Mr. Maggio, did that answer your question?
Thank you.
All right. Yes, Commissioner Topchian.
Just a quick question, Mrs. Sapernia, you mentioned the measurement for the living room. You said 10 by 12.
That's what it is. And your
Because the
Inspector
inspection
Lopez said,
report
yes,
says 12
200.
feet by 17 feet. That's the living room, and the dining area is 10 feet, 11 inches by 13 feet, 10 inches. This is quite a different measurement, and per the inspector's report, it's a wider area. And
Okay, I understand.
how do you explain that?
Mr. Dennis said the living room was 450 square feet. I had the technician measure it. I do not measure myself. He said
Okay.
it's 12 by 10. I said, what is 12 by 10? He said 120 square feet. Also, the general contractor, prior to installing this, he also measured it. And he said it was about 120 square feet. The dining room next to it is smaller, so possibly together there are 300. But this unit, we researched and we looked for something that covers not only the living room, but also the adjacent dining room. Both of them, according to your code officer, is 300. So this unit covers 500 square feet, not just the living room, but also dining room. I videotaped it, and also this technician that I took there, who is an expert, that his testimony is is an expert testimony. He measured it.
All right, you answered the question, sir, about the measurements. Thank you.
All right, thank you, Commissioner Topshian. Other questions from commissioners? Seeing none, all right, Mr. Sapernia, thank you. You can mute. We are going to enter deliberations now. Who would like to start? All right, Commissioner Kerpes, thank you.
Thank you, Chair. So I'm having difficulties in determining whether this is something that we can come to closure with tonight, right now, or whether it needs to be remanded. And I'm leaning towards it's something that we can determine this evening, but at the same time, I don't want to take away any of the rights that the landlord has in terms of refuting evidence like that. So I'm going to give you what I think that we are looking at tonight based upon what I'm reading in the original hearing, actually dating back to 2018 when the city notified the landlord that the heater was not, did not meet the code, the damaged heater did not meet the code. And you can see that on page 86 in our packet, where on November 19th in 2018, the city advised Mr. Saperani that the lack of safe and adequate heating in a dwelling unit was unlawful under West Hollywood Municipal Code. So that to me starts the basis for, if we're going to talk about heating, that sets the basis or the ground floor of what we're talking, what the heating is of. Now, throughout our entire packet, where we see the living room heater, the living room heater, the living room heater. Well, to me, I see that as the heater that's placed in the living room. I wouldn't call the living room heater, I wouldn't call it a living room heater if the heater was placed in the hallway or the bedroom. But I might talk about the heat of that part of the house, which they often did in the original hearing, the front part, the new or the old part versus the back part, the new part. So in the dialogue that they're having throughout this entire case, it's not about living room heat. There are a couple references where they talk about the temperature in the living room, but there's never a conversation about how cold the living room is. It's this part of the house versus that part of the house. We all accept the fact that the big heater in the back doesn't heat the entire house. We understand that. The little heater in the front, I mean, we can see from the pictures that it's a different type of heater. We don't have to draw, we don't have to, as the attorney, Mr. Frost mentioned, we can use common sense. That type of heater allowed heat, whether it was pushed out on that side or it was just able to flow freely, it allowed heat out on that side of the wall. I would make an assumption, I think it's pretty common sense, that both sides of the wall got some sort of heat. This, I think everyone is agreeing that, and even the landlord is stating that his intent basically was only to heat the living room. I don't understand that coming from a landlord. You would think that you would want to buy a product that would heat the living area, the home. But you know, that's beyond us. But I think the context throughout the entire case has always been about the level of heat in that part of the house, not the specific living room. That's only the location of where the heater was, not necessarily what was being heated. I think that I often rely heavily, and I do on this case, the third party, the city, when they inspect a unit. I think the inspection did two things. It showed us, gave us a number, an enumeration of what the heat difference is over a 20-minute period, 4 degrees. I don't have anything to compare that to. I think that that's not enough. I think that, but that's just my own opinion. So then I refer to the second part of the inspection, and the inspection was, after 20 minutes, I walked from the front door past the heater, and I only felt the heater when I got within 2 feet of it, I believe. That to me, after 20 minutes, not noticing the difference, to me is also a valid observation that I will be relying on. Again, I do, and I look to our staff attorney to point out if I'm missing any parts of his recommendation that should still, even if, let's say, the entire commission were to agree with my analysis, if there are still holes in that he believes we should still remand on a certain point back to the hearing examiner, and I'm happy to entertain that idea and think more about it. But I don't see in this case where, when we come down to the question at hand of whether the heat was restored, why we need to go any further than what we have. And I'm prepared to make a decision this evening in this case. But again, I'm very much open to hearing what our staff attorney has to say about that and what all of you have to say.
Thank you for that, Commissioner Kerpes. Further comments, commissioners? Yes, Commissioner Ayers.
Thank you. I really appreciate Commissioner Kerpes' analysis of the situation. I agree that, especially that this is something that perhaps we can make a determination on today without remanding it back to the hearing examiner. And that's really all I have to say.
Great, thank you. Commissioner Topshan and then Commissioner Maggio.
Thank you, Chair. At this point, I just want to mention that, well, first I concur with most of the things that Commissioner Kerpes have said, and specifically in regards to the comparing the old heater to the new one. The old heater, clearly, based on the pictures, you can see from both sides of the wall that provides heat to the both sides of the wall, to both areas. I mean, the parts of the house. But I want to go back to the question that I asked the legal counsel at the beginning, is regarding the kitchen, whether the kitchen was part of the discussion at the hearing. So by its definition, when you talk about this legal rental unit, and the rental unit, the definition of the rental unit, it includes also the kitchen area. And by the way, when you read the examiner's decision in regards to the rent decrease, it's on under testimony and exhibits part on your in your packet is page 85. it references the address, and it describes, it basically provides the description of that unit, which is a living room, dining area, kitchen, bedroom, and office. So when I read this, and it provides the approximate size of 1,100 square feet. So when I read this, and I know that anything that would be discussed, at least about the heater, that would be applicable to the entire 1,100 square feet area. Why? Because heating is an essential habitability service that must be provided. It's part of the code. And when we talk about heating, providing heat to the unit, we're not identifying separately the heater for heating for dining room, heating for bedroom, heating for bathroom, heating for kitchen. So when we say the owner is required to provide adequate heating, that applies to the entire unit. And that unit also includes the kitchen area. So here that obviously when we talk about the applicable codes that are referenced in the analysis, the maintenance standards code. So I think maybe there would be some sort of a clarification on that, but I doubt that there would be a discussion about what is the size of the heater, how many BTUs have to be the heater in order to be an adequate heat provided to the unit. But in my opinion, when we talk about the heating to the providing heating to the unit, it's heating to the entire apartment, entire unit, with any area and all the areas should be covered. Because if it doesn't, based on what we see here, if this is only about the living room, then we're saying that the bedroom doesn't have any heat. Then we're saying that the bathroom doesn't have any heat. That means the unit is not in compliance. That means the unit is not up to code, because the unit doesn't have heat only in the living room area. So that is the problem I'm having, and I have no issue with remanding this back to the examiner, but I want to make sure that when we remand this, there won't be a question that the kitchen was not included in the whole thing. Because when they were talking about the heating to the unit, that automatically, by its definition, should have been included the kitchen. Because right at the beginning, as I said, it describes what this 1,100 square feet apartment consists of, and that includes kitchen. So that's one of my concerns regarding the kitchen. The other thing is the measurements. So it seems like there's inconsistency with what the tenant says, the landlord says, in regards to the measures of the living room and the dining room, etc. So I have no reason not to trust the professional observation of the code inspector. So when I read the report and it says the living room measures 12 feet by 17 feet, so then I trust that report. And it's not in every case. It's that the inspector would go out to inspect a unit. And I actually appreciate that the examiner requested this inspection. I wish, though, that this inspection report would have been a little bit more detailed, would have included more information. But that I believe that the specifics of the issues that were requested by the examiner should have been probably more detailed, so then the inspector would have provided a little bit more information. But when I see that the temperature went from 65 to 69 degrees, it's only a 4 degree, and it's within 20 minutes and within the 2 feet distance, that clearly doesn't provide adequate heating even to the living room. So there's no doubt in my mind that this heater was not the substantial restoration of the reduced service. So now I still believe that maybe we need to, I want to hear other commissioners, what they have to say, but maybe we should remand back to the examiner to just cover other questions. But I would have actually said that based on the evidence that I have before me, that the owner has not complied with the decision of the examiner. But because there are unanswered questions and we expanded by a discussion among the commissioners those questions, so I'm okay to remand it to the examiner. At this point, that's all, Chair. And if I have another thing, another question, I would just say, maybe another thing is, sorry about that, maybe the discussion about the BTUs per square footage, if there's any mentioning in the code, if we're talking about the heat, which I doubt, but maybe there is some sort of explanation how much heat must be provided to a certain square footage. I don't think that would be possible to have in the code, but just in case, maybe that could be also addressed if the case goes back to the examiner. And also, if the examiner will receive the landlord's contractor's report, where the landlord stated tonight that there was an independent, or there was a contractor hired by the landlord. I wouldn't say that's an independent contractor, but then maybe the tenant would have that same option, that opportunity to get his contractor if the tenant wish. I think that should also be presented to the tenant as an option. So then later wouldn't be, okay, so the landlord had the contractor's report and I didn't have a chance to do so. And to see whether that will help the examiner to maneuver among those two reports and the city's inspection report. Thank you, Chair.
Thank you for that. All right, I think Commissioner Maggio was next.
I think this is going to be difficult to have any resolution unless it really is remanded. Obviously, the old heating system did the job. The system's 96 years old. There's no one to correct it, to bring it back to what it was. And although I think the owner has definitely shown due diligence in replacing one heater, and then wanted really to go on to install a larger heating unit in the living room, which the tenant rejected because they wanted wall space. I think that was a mistake. I think the owner should have just gone ahead and put in that larger unit, and I think that would have created the compliance. So because I think there's all these details that still need to be worked out, and they're not going to be worked out here, I don't think, tonight. So I'm all for remanding this so that the hearing examiner could really explore this in greater detail, and I think definitely could come up with a resolution. Thank you.
Thank you. I think Vice Chair Copeland.
Yes, in reading the file, the tenant's official request form to the landlord on 12/11/18 stated, replace the heating in the front of the house. So as Commissioner Kerpes and Topchin pointed out, that's not the living room. I think there's some confusion because the word furnace has been interchanged with the word heater. And originally there was a furnace located in the living room which provided heat to the front of the house. And this is a different delivery system. I think the hearing examiner did have sufficient evidence to determine that it was not comparable. I am not, his order was that until the living room furnace is restored, the rent should be decreased. He didn't say living room heater or heat in the living room. But I think I think he had enough evidence to make the determination that he did. But I would not be opposed to a remand for more specificity if my fellow commissioners felt that that needed to happen. But I do not think it's comparable, and I think he had evidence to, including the code compliance officer's personal visit. I think he had sufficient evidence. But if we need specificity or more research or something on the record, I wouldn't be opposed to remand, but I would lean toward upholding myself. Thank you.
Thank you for that. All right. So I have a couple comments to staff, and then I'll discuss the case. I know we've been in a pandemic and whatnot, but throughout this case and then a number of cases, as Mr. Frost pointed out for this matter, these cases go on a long time. And I know part of that is just the nature of the beast. It's government, it is appellate stuff. It's slow. I'm an attorney, it's slow. But for both parties, I think as much as possible, the more we can speed these up, the better, because it's cliche, but justice delayed is justice denied. And if I was in either of these parties' situations, the landlord or the tenant, 2 years or whatnot would be extremely frustrating. So as much as we can speed these up to provide the best service to our residents and our landlords and tenants, that would be amazing. To the parties here tonight, thank you for well thought out comments, for being respectful. We don't always get people who are able to put their thoughts together, not fight with each other, even though you are on opposite sides of the matter. So I appreciate that greatly. As to the matter at hand, it's close. I think seeing our fellow commissioners discuss tonight, there's people on both sides of this. But as legal counsel points out, and as our duty states, we go back to the question that is our duty. Is there substantial evidence in the record to support the hearing examiner's decision? As I said, it's close. I am a yes to upholding this decision. Commissioner Kirby's made really good points. Vice Chair Copeland as well. Everyone has made good points, but I think the hearing examiner could have made a fuller record, but that's the case in many legal matters. You don't always get a perfect record. And as the appellate body, we have to take what's given to us and determine whether it is substantial enough to do our job or to remand it. And here, I think the record is solid to uphold the decision. That the hearing examiner's decision on the compliance determination that the heat was not properly restored. And I think Commissioner Copeland, Vice Chair, makes great points about the type. I think the hearing examiner was able to make a substantial decision based on the evidence presented to him prior, but also the compliance determination made by city staff. I think it was Commissioner Kirby said he places a lot of great emphasis on that, and I do too. I think the compliance determination was done by city staff. They went out, they made a finding, and that was part of the record that was used by the hearing examiner to find that this compliance determination had not been met. So with that said, I would vote to uphold the hearing examiner's decision that the landlord was out of compliance in this matter. So if we don't have further comments, I would entertain a motion.
Chair Mark, can I just interject real quick?
Yes, you may.
So if the commission wants to affirm, or ultimately, however you guys vote, but ultimately it's decided that the commission wants to affirm the hearing examiner's decision, my recommendation is, because I'm not going to have time live to make all the changes to the resolution, if you could just have it be like a straw poll first to see where the commission's at, and then ultimately the motion would be to order staff to come back with a resolution for next meeting to approve. That's only if you go opposite of what staff's recommendation is, but if that is how it goes.
Yes, that is fine. Mr. Secretary, would you take a straw poll, which is not a motion or a vote, to see where everyone stands? And this would be to uphold the hearing examiner's decision on the compliance determination. And then based on that, we will entertain a actual binding motion.
Commissioner Ayers,
Yay.
Commissioner Kirkpatrick,
Yes.
Commissioner Maggio,
No.
Commissioner Topshin,
Yes.
Vice Chair Copeland,
Yes.
Chair Marks.
Yes. All right. Based on that straw poll, I would entertain a motion based off of legal counsel's recommendation to have staff come back at the next meeting with whatever the motion party would like to say.
Second.
All right. And so as the party that kind of made that motion, the motion is to have staff come back with a appropriate resolution drafted that upholds the hearing examiner's decision to find that the landlord did not comply with the compliance determination in this matter. Mr. Secretary, if we could have a vote on that, please.
Do we need a second?
Yeah, that was me. Sorry.
Oh, sorry. Commissioner Ayers,
Yes.
Commissioner Kirkpatrick,
Yes.
Commissioner Maggio,
No.
Commissioner Topshin,
Aye.
Vice Chair Copeland,
Yes.
Chair Marks.
Yes. All right, the motion passes with 1 no. The parties will be placed back in the waiting room. Again, thank you to both of the parties. If you do have questions, the Rent Stabilization Division is available. Their email is rsh@weho.org, rsh@weho.org, or phone is 323-848-6450. Again, 323-848-6450. Thank you again to the parties.
Thank you all for your time.
Thank you, Mr. Frost. All right, Mr. Holub, I believe we have a presentation now on our agenda.
Could we ask for a short recess before we go on to the next work?
Yes, we will take a recess until 8:22, 4 minutes or so. All right, it looks like we have everybody back. We are on to our new and unfinished business. It looks like we have a presentation for this evening from staff.
Thank you, Chair. Good evening again, Commissioners. Jonathan Holla, Brent Stabilization and Housing Manager. This is the return of an item that you debated on June 10th, stemming from a recommendation and request to revise the rent stabilization regulation 42000, which sets forth the formula by which security deposit interest shall accrue. Just as a little background for folks who might be coming to understand this for the first time in the viewing audience, the RSO directs that in each calendar year, interest on security deposits retained by landlords shall accrue at rates to be determined annually by this commission. And the commission is the body that sets that formula. When actually later this evening, the announcement of the interest rate for this calendar year will be announced by Yasmin Spiteri, and it will continue to be related to the existing regulation, obviously, since no action has been taken on this matter yet by you or the council. In the meeting on June 10th, staff made a number of recommendations, and the commission specifically directed staff to come back with a formula that was to look at 5 FDI insured online savings accounts and round that to the nearest 1/10 of 1%. That is what staff has presented here this evening in a draft regulation. There was some discussion about guardrails or guidance. So what staff proposes is a regulation that requires staff to look at initially bankrate.com, which is a well-established aggregator of all kinds of financial products. And if that isn't available, to find another comparable site. But given the history of Bankrate, I anticipate that it will be around to observe and make a determination from. Of course, if that changes, we can always revisit the regulation. As part of the staff report, in order to give a sense of how this regulation might change the outcomes, staff put together a hypothetical if the regulation were in effect currently. And you can see in the staff report that the top 5 banks with the highest interest rates with a minimum deposit of no more than $500 were picked. Those figures are in the staff report, and it comes to an average of 0.516%. The direction was to round to the nearest 10th, so it would be 0.5%, which is an increase from the most recent years, where the formula has resulted in 0% interest. So this is the formula that's been presented. Just for everyone's benefit, the substantive language would be as follows: on or before September 1st of each year, beginning next year, 2022, the commission will announce the interest rate to be paid on security deposits for that calendar year. This rate shall be calculated by averaging the interest rates for savings accounts of 5 online FDIC insured banks, rounding to the nearest 1/10 1%. The banks shall be those with savings accounts with the highest annual percentage yield and requiring no more than a $500 minimum deposit, as listed at bankrate.com or a similar consumer financial services company in August of each year. And that's the substantive change to the regulation. Otherwise, it remains substantively the same in terms of when the announcement would be made, when the landlord would be required to make that payment or to grant the credit. And that's my report, and I'm certainly available for any questions. Thank you.
Wonderful. Thank you for that report. Commissioners, any questions? Oh, none? This was a lively conversation last time. Sounds like staff made commissioners happy. If there's not any voices here, I will just say, I think Commissioner Kirkby, go ahead.
Oh, I was just going to say, I don't have any questions. I just want to thank staff for putting this together because, you made it so easy here tonight. Like I remember leaving with like, I wonder how they're going to put that together. Okay, I trust that they're going to do something, but this just makes it look like you guys didn't have to do any work at all, and you just brought this proposal back. But I know that you guys had to do a lot of work, and I appreciate it, and especially how quickly you've done it. So thank you.
Thank you.
I will echo those comments. I think that when we had this discussion in June, it was a lot of different voices and different comments in different directions, and being able to distill what we said from a lively debate that was focused on what's best for the regulation in the city, but different comments. I think from my perspective, this brought it back to as close to what we were expecting as possible. So I appreciate that. So do we need to take a vote on this?
Yes, the recommendation would be to make a motion to recommend to the city council that it approve this draft resolution.
Wonderful. Anyone want to make that motion? All right, I see Vice Chair Copeland. Any second?
Second.
All right, Commissioner Maggio. Mr. Secretary, a roll call vote, please.
Commissioner Ayers,
Aye.
Commissioner Kirkes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Topshin,
Commissioner Topshin, Vaughn.
Aye.
Thank you.
Vice Chair Copeland,
Aye.
Chair Marks.
Aye. The motion passes. Thank you, Mr. Hollow, Mr. Secretary, for that. Moving on the agenda, items from staff. Do we have any staff items?
Right. Oh, sorry.
There was an item, an unfinished business item.
Yes. Sorry.
No problem.
One second here. All right, sorry, I don't have that in front of me. My computer just blipped out. What is the unfinished item?
It's just the announcement of the interest rate, which I thought maybe you thought was a staff item. That's why I was like, oh, wait, maybe not.
Yes, that is what I was expecting.
Yeah.
Written down.
It's actually under new business, part B.
Thank you. Sorry, my computer is part B. There we go.
Do you have it, Mr. Chair?
I don't. My computer's still frozen. If someone would like.
So it's just new business B, announcement of interest rate on security deposits held during calendar year 2021, which I believe staff is presenting.
Yes, that would be great. I'm going to restart my browser.
Am I good to go?
Yes. Thank you.
Thank you. Good evening, everybody. Chair, Vice Chair, Commissioners, good to see you all again. So as Jonathan mentioned, there is a section of our municipal code, section 17.32.020, that requires interest to be paid on security deposits every year. And every year, the Rent Stabilization Commission announces that interest rate that landlords need to use when calculating the accrued interest rate for the security deposits they hold for tenants. The interest rate is announced before September 1st of the subject year, and interest is either paid to tenants or offered as a one-time rent reduction before February of the following year. So before February 2022 in this case. And so as far as the calculation of that interest rate, it is calculated by averaging the July 21st or the July 1st, 2021 interest rates for regular savings accounts at 5 West Hollywood banks. So that means 5 banks in West Hollywood that have physical locations within the city boundaries. And so averaging the rates for 5 of those savings accounts and then rounding to the nearest 1/4 of 1%, which is what was amended tonight. But for this year, we're still using the old formula. And the 5 banks that we looked at were Bank of America, Wells Fargo, Citibank, One West Bank, and US Bank. And the average rate of those 5 was 0.024%, which rounding to the nearest 1/4% results in a rate of 0%. Therefore, pursuant to the rent stabilization regulation 42000B, the security deposit interest due from landlords to tenants for calendar year 2021 on their security deposits held for this year is 0%. That's it for me. Thank you.
Wonderful. Any questions from commissioners? Yes, Commissioner Topshian.
Just, hi, Yasmin. Good to see you. How are you? Although it's 0%, it's still going to be published, I believe, right, in our newsletters or on the webpage or anywhere else. If you can just provide that information, and I believe it's going to be in Russian and Spanish also.
Yes, so it will still be announced and spread widely on our website and the newsletters. Yes, it will still be promoted.
Wonderful. Other questions? I see none. All right. Thank you for that presentation.
Thank you.
All right. I have restarted my browser. That concludes the new business, item 10. We will move on to item 11, items from staff. Do we have any staff items this evening?
No further items. Just wanted to thank the commissioners for their kind words and for their diligent work on the item, and to Yasmin for her really hard work in presenting a great item that everyone was able to work from. So just wanted to express my appreciation for that. Thank you.
Wonderful. Thank you. And I echo those comments. All right. Moving on to item 12, public comments. Do we have any public comments now?
We have no public comments at this time.
Nope. No public comments. Okay, wonderful. Thank you. All right. Moving on to item 13, commissioner items. Anything from commissioners? Yes, Commissioner Kerpes.
Sorry, I guess I should have mentioned just at the beginning. Maybe we have a few more viewers now, but so before our next meeting on September 4th, the federal benefits, extended benefits that are given to unemployed individuals and those who are self-employed that have been receiving benefits this last year, those will all end September 4th. This will come to a surprise to many, and will also be, have a huge impact on several 100,000 Californians. And so I just want everyone to be aware of that, to maybe think of ways that we can somehow all help others, because September 4th, it would be, quite a shock to the system when these individuals who have many already been struggling for months to try to get the benefits that they're owed to them from EDD, but now they're going to stop completely. I think out of the people who have benefits, 550,000 Californians will have regular UI unemployment insurance. They will continue with whatever balances they have in their current funds. There's about 1.3 million Californians who will lose all benefits completely because they are the self-employed individuals on the PUA, the PUA, the Pandemic Unemployment Assistance. And then there's about 1.3 million Californians who may have qualified for unemployment insurance under UI, the regular traditional program, but have, because they didn't find a job after 26 weeks, they've been on extensions provided by the federal government. Those extensions will come to an end. And it's a case-by-case basis for those individuals, whether they have weeks left remaining on their previous claim or not. So be thinking about those people over the next couple of weeks. Thank you.
Thank you, Commissioner Kerpes. Other commission comments? Yes, Mr. Maggio.
To Commissioner Kerpes, so therefore, even if there is additional funds already in place, they can't collect. Is that correct? Because this all stops on September 4th.
As of now, we don't, yeah, there, so
thought it
the
was
federal benefits end. If they have, even if it shows that they have a balance of funds in their account, if they're on the federal programs, if those are federal dollars, those will end on September 4th.
They will what?
Those will end on September 4th. Those will disappear from their account.
Thank you.
Alrighty, additional comments? I see none. All right. Let's see here. All right. Items from commissioners is complete.
I believe Vice Chair Copeland's raising her hand.
Oh, thank you. I appreciate that. Vice Chair Copeland, go ahead.
That's okay. I just wanted to echo the sentiments of thanking staff and our housing manager for making all of this a little bit or a lot easier for all of us. And we're able to throw our ideas out, and, you know, sometimes it drags on a while, and they're unflappable. They're very patient, and they come back with something that makes it look so simple. So I just wanted to say thank you so much. Appreciate you.
Thank you for that nice comment. All right, looks like we have no further commission comments. Moving on to adjournment. The next meeting of the Rent Stabilization Commission will be held at 7 p.m. Thursday, September 9th, 2021 via teleconference. This meeting is adjourned. Thank you all.
Good night.
Good night. Thank you, everyone.
Good night, everyone.
Good night.
Good night.